Hi everyone, you're watching The Business of Law, the only web TV show focusing on the challenges and opportunities facing the legal profession. I'm Lee Pacchia. Joining me today, I'm happy to say we have Tim Corcoran. He has been stewing in the green room for about 20 minutes and he's all kinds of worked up, so this should be a particularly good segment. Thanks for coming on.
Happy to be here.
So you are really unhappy with some, maybe all bar associations in general. Why is that? You're the president of the Legal Marketing Association. Shouldn't you be getting along with these organizations for the general betterment of all those involved?
Well, I'll tell you, Lee, I'm angry and I don't care who knows. No, I'm not really upset at all bar associations. I will say that on occasion, the bar associations as a whole and then some unique associations around our marketplace are not necessarily doing the right things to advance the profession. And so I think it's important to call them out.
Yeah, you had a really tough article that you put out, I think, about a week ago on your website. I suggest everyone go read it. Can you walk us through the general thesis of it?
Sure. Essentially, the Texas Bar Ethics Commission issued a ruling stating that law firms should not have non-lawyer executives with senior titles or with compensation that is in any way formulaically linked to the law firm performance, because doing so would clearly impact the lawyer's ability and judgment in practicing law and would harm the consumers of legal services. And so no senior titles, no C-level titles, and no big pay packages. Those non-lawyers should be pushed off to the side, essentially is what they were saying.
And generally speaking, how many firms in Texas does this affect? I mean, we've seen this as a trend developing with big law organizations all around the world. How many firms within Texas are probably going to be affected by this?
Probably many hundreds, and I don't know the exact number, but certainly all of the big firms in Texas banded together to write a letter saying, this is ludicrous. We don't necessarily believe this is true. We have some very fantastic senior executives who are not practicing law helping to guide our business, and we believe that we should be able to reward them and give them the titles that are commensurate with their experience.
But presumptively, there's a concern here to protect the interests of the consumer. I mean, is there anything valid in what they've done in your view, or is this just, have they just completely missed the mark?
Sure. Well, let me do this. I'm going to read a quote. This came from a couple years ago from the ABA Commission, where they're talking about whether or not we should have outside investment in law firms. Very similar topic.
It's a big topic.
The idea is that non-lawyers might not have the same code of ethics. They might not be bound by the same sense of professional responsibility and might push the lawyers to do things that they should not be doing to chase the dollar rather than abiding by the rules of professional conduct. So, Lee, speaking as a former CEO, my answer to that is exactly. The last thing we need is more lawyers protecting the profession and protecting clients from change and evolution, because that's exactly what clients are looking for. And so when a bar association puts forth an edict that says we don't want to advance the profession because doing so might actually achieve the aims that the clients are pushing us for, then that's a problem.
So we're talking about the fundamental concept of a bar association in general. You're saying it's anachronistic at this point? I mean, are you arguing to do away with them in general?
I don't necessarily have a problem with bar associations, but let's understand what they are. They are not an independent ombudsman reflecting the moral fiber of our community and how we should administer the practice of law. They are associations of professional lawyers who self-regulate, who decide their own rules, who decide their own competition, and while there's no nefarious intent, why is it a surprise that they are really confusing at times what's right with what's right for the profession? And so when the clients are saying, this is what we want, and the bar association says, no, we don't want you to do that, well, there's a problem. And so they need to stop doing that.
So what's the prescription here? What would you like to see done?
So what needs to happen is listen to the clients. If the bar associations want to serve the modern era of the legal profession as it evolves, what they need to do is listen to what the clients are looking for. Now, there's two different kinds of clients. There are consumers of legal services like you and I might do when we close on a mortgage or we have a trust and estates issue or a will. And then there's sophisticated buyers of legal services like my former role in an executive. I didn't need a lot of help coddling me and making sure I didn't get bamboozled by these corporate lawyers. I understood what I was looking for. I understood my risk profile of my organization. I had a pretty handsome budget. I knew what I was spending. And so I didn't need the same kind of protections. What I wanted was a lawyer or a firm or a bar association making sure that my counsel understood my business. And I don't mean just read my quarterly earnings statements or read an industry analyst report, but really understand, how do I budget, what's predictability mean to me, what's risk mean to me, and what are the business impacts of the legal issues I'm bringing to you. And too many lawyers don't have that sense, but they could bring that sense in with their professionals.
I got to push here because it's a vexing problem. We're seeing a lot of people come on this show and talk about how the nature of practicing law has fundamentally changed, and we need non-lawyer executives in the C-suite of these organizations running the business matters of law firms. And when you see opinions like this come out, it's not just a philosophical problem. This is a nuts and bolts issue. So what can be done if, say, you were in a position of power at one of these bar associations to get out of the way and let law firms run themselves on a better footing?
Well, first thing I'll say is I don't know that it's only lawyers should run law firms or only non-lawyers should run law firms. I think there's every reason to believe that the professionals who come in with experience outside of the law practice and can bring in tried and true sound business practices to the law firm, once adopted, these lawyers are smart people. They'll figure out how to run their firms and embrace these concepts. I think the challenge is when you say, nope, can't have a non-lawyer in a senior position. They might influence the practice of law. They might be guided by profit motives. Well, that also sort of accepts as a standard fare that the lawyers aren't themselves motivated by profit. Of course they are. But they're also bad at it. If they were really motivated by profit and they were good at it, they would say, what can we do to serve clients' needs? And that's what a bar association can do. Be the voice of the client. If the lawyers aren't listening, let the bar association be that voice of the client.
So we've just talked about the Texas Bar Association for about 6 minutes or so. Is there a bar association in the United States that gets this kind of stuff right in your view?
I think bar associations by nature are reactive, not proactive. So I see very little from bar associations that are trying to set the bar high, no pun intended, but sort of say, here's the agenda for the next 20 years. I think what they're mostly trying to do is soften the blow of how to make sure that we don't have too much change too rapidly, because they're trying in good faith to protect the consumers, but they're also protecting the guild of lawyers.
Right, and they wonder why lawyers are adverse to change.
That's right.
So let's talk a little bit about the P3 conference. We have project management, pricing, process improvement. Are we seeing progress on any of these fronts? How'd the conference go?
Well, this is what's interesting, is the same week the Texas ruling came out, or at least made the most noise, we are hosting a conference in Chicago. The Legal Marketing Association produced this conference, but it's not marketing, it's pricing, it's project management, it's process improvement. It's teaching law firms how to profit from efficiency at a greater magnitude than they've ever profited from inefficiency, teaching them how to run their organization like a business. And the room was full of lawyers, but also pricing professionals, chief marketing officers, chief financial officers, there to learn and embrace these concepts, adapt them to the law practice, and take them back to their firms. So on one hand, we hear one headline in the news is, stop getting these non-lawyers giving you advice because you might disrupt the practice. And the other hand, we've got folks sitting in a room saying, here's exactly what clients are looking for. At the same time, we can improve our own financial performance, we can improve the quality of our work product, and we can meet the client expectations. Who wouldn't want that? Well, as it turns out, the bar associations.
Tim, this is wild stuff. I hope you come back and talk to us as it develops further.
My pleasure.
That's Tim Corcoran. He's the president of the Legal Marketing Association. If you'd like to see more of the stuff we're working on, be sure to go check us out online. You can see us at mimesiswebtv.com. You can also follow us on Twitter, and you can always follow us on YouTube. I'm Lee Pacchia. Thanks for watching.